Hi, Bill Henshaw here again, back with my You Win in Court YouTube videos, and I apologize for a bit of a delay here. I've had an unfortunate run-in with what thankfully looks like a garden variety case of enlarged prostate. So I haven't had the good health and the energy that I normally would have over the course of the last few weeks. Hopefully this will be coming to an end in a couple of weeks. I have some things to do and this, that, and the other. But that said, I'm back now, and I'm going to pick up with a very important case that you need to know about pursuant to these forthcoming mandatory government vaccinations with this COVID pandemic bullshit. Whole thing has been a fake from day one. There's no pandemic. And by the way, a pandemic, best definition you can get of that is 14th century with the bubonic plague, wiped out 25% of the population of Europe. That's a pandemic. What we have here might be as much as 1/100th of 1% fatality rate. And I think those figures are seriously inflated. You might want to check on YouTube with Dr. Andrew Kaufman, MD, about that. But even at that kind of a number, it's minuscule. And most of them are in the high risk group, which is like yours truly here. I'm going to be 72 in a few weeks. But the whole thing is a scam. And the New York bankers are running this so that they can get into a state of overt federal regional martial law rule. Now, we've been in that condition for 85 years, covert. And if you send me an email, uwinandcourt@gmail.com, I'll send you some bonus documents. One of them is Senate Report 93-549 that talks about, at the time, 40 years of perpetual ongoing states of emergency in which all normal constitutional laws were suspended. It's gotten even worse in the next 45. We have an unprecedented window of opportunity to stop it here, especially with mandatory vaccinations, because most people, if they won't do anything else, will stand up and defend the rights and safety of their children. And we can do that if we use the right issues. Problem in Jacobson v. Massachusetts is nothing remotely resembling that occurred. And I'll read you some excerpts here. Starts out, the United States does not derive any of its substantive powers from the preamble of the Constitution. What? Most of you don't even know what the hell that is. I don't remember learning that when I was in school either. But you read that and you find out that we the people ordained and established this Constitution to ensure the blessings of liberty to ourselves and our posterity. At the time, our posterity meant, and get used to it, free, white, male, 21. That's the way it was. That's the way it is. Lawful de jure, jus sanguinis, free, white state citizens. That is not a racist statement, however, because in the system we had, and we want to get back, inhabitants of territories had a hell of a lot more rights than anything remotely resembling the 14th War Amendment, which was never enacted properly. We're doing a video on that upcoming too. But there were real rights out there, not all this BS war powers crap that Congress enacted in the 1860s. So that said, we get back to local government with responsible local parties. We can instruct our representatives who will be represented in local councils and the state legislatures, and those changes will be forthcoming. And now we have rights they have to respect and limits on their power, that they're bound by this Constitution and the laws enacted in pursuance thereof. Ball game is 180 degrees different if you're a 14th War Amendment citizen and subject to the jurisdiction of the United States, not to mention being unlawfully construed pursuant to fictions of law as an artificial corporate entity. That's how bad this crap is. And nobody that ratified the amendment was aware that any of that was going on. So where's the consent of the governed here, you might well ask. Going back to Jacobson. Goes on, with the exclusion of evidence in the state court in a case involving constitutionality of the statute may not strictly present a federal question, this court may consider the rejection of such evidence on the grounds of incompetency or immateriality as showing the scope and nature of the opinion of the state court. Problem with that is, U.S. Supreme Court, and just about everything I get ultimately comes from there. Cohens v. State of Virginia, 6 Wheaton 264, page 403. Chief Justice John Marshall, that infallible icon of Harvard and Yale, who was never wrong, was he? Said, in effect, that no matter how small the case, nor how little interest the community in its outcome, The framers of our Constitution thought it wise to prepare a tribunal as superior to influence as possible in which that claim might be decided. We have a right to be in front of the 9 old farts, aka the U.S. Supreme Court. We don't go there on the appellate jurisdiction and beg their indulgence. That's not how it works. Situation here is principal and agents. We tell them what to do, not the other way around. When's the last time you've seen that lately, especially on the TV news and CNN with Wolf Blitzer? It just doesn't exist, and this is what we have to get changed. We have an unprecedented window of opportunity here where people will actually stand up and fight for their children if they won't do it in any other way, and prevent them from getting these compulsory vaccinations with who knows what's in it. I mean, that's an interesting, by the way, if you want to check it out, go to Andrew Kaufman, MD on YouTube, check his videos out. He says it with credentials and with clarity. So feel free to do that. Going back to Jacobson, the local regulation, even if based on the knowledge, police power of the state, must always yield in the case of conflict with the exercise of the general government of any power possessed under the Constitution. The mode or manner of exercising police power is wholly within the discretion of the state, as long as the Constitution of the United States is not contravened. Wait a minute. Now, we have under Article 1, Section 10, says no state shall pass any laws that impairs obligations of contracts. So what that means to me is if they come knocking on your door, needles and maybe bazookas in hand, you say, just a minute here. We're not agreeing to this contractual thing you're trying to foist off on us here. We've never agreed to it, and in fact, we've refuted it in paperwork, which I'll teach you to do. Send me an email, uwinandcourt@gmail.com, about my document packets, and I'll get information to you, because you've not agreed to it, and we have an unlimited power to contract. Here again, that's principal and agent. We're presumed to be competent. Exactly the opposite of what occurs in any department of the de facto national socialist government, especially the so-called damn trial courts. And that's another reason we won the Oakland case, by the way, is that we never let them get away with that. And that's why they couldn't go to trial, because they're going to get me, my friend, and her son, who's in jail, on the witness stand telling the jury exactly what the hell is going on. And they finally figured out they couldn't dare risk anything like that. So therefore, times for a plea deal, case over. So this is what we have to start doing, is acting like principals and treating them like agents, and telling them what to do. That's what it is we're supposed to be doing here. So it goes on in Jacobson, that the highest court of Massachusetts, not having held that the compulsory vaccination law of the states establishes the absolute rule that an adult must be vaccinated even if he's not fit. The statute is not invalid as a derogation of any rights of such person under the 14th Amendment. Now, kiss my ass. That's not what we argue here. And you go again to the U.S. Supreme Court, Ashwander v. Tennessee Valley, 297 U.S. 288, 341. 7 rules that what they will hear and what they won't. And they say right there, in effect, that the court will not construe a law broader than to apply to the precise facts upon which the case is made. In other words, Jacobson went there under the 14th Amendment. We're going under there very arguably under all 6 articles of the Constitution. Completely different case, and we're challenging authority from day one. You don't have it, and they don't. And we can prove it. You'll learn a whole lot about that by getting my document packets. Okay, no quorum to do business, no racial representation, no Republican form of government. I mean, you name it, it just goes on and on. So that's where we need to get to, and we have a great window of opportunity to do this. I'm hoping to be able to do it successfully in the next 4 to 6 months before the vaccinations hit the market and stop these bastards. So we'll see about that. But that said, anybody that talks about Jacobs that doesn't know what the hell they're talking about, and don't walk to the nearest exit. If you get somebody like that talking to you, you don't need to waste your time with them. Bill Henshaw here again. This is a continuation of the video I just did on Jacobson v. Massachusetts. As I meant to mention, that case is often discussed almost in the same breath with Buck v. Bell, 274 U.S. 200. Case of Carrie Buck, who was a 17-year-old kid in a mental institution in Virginia, embarrassingly enough for me. And she got what she thought was a relatively safe operation on her appendix, but what they really did was sterilize her without her knowledge or consent. And she later got out, got married, couldn't have kids, and they finally went to the doctor, and he detected it and told her what happened. And she brought a lawsuit against these bastards in this mental institution for doing this, which seems like as clear a case as you can possibly have. No knowledge, no consent. What the hell is this? And the U.S. Supreme Court has said, by the way, in a later case, that they require a voluntary, knowing, and intelligent waiver of rights. Johnson v. Zerbst, 304 U.S. 458. And yet the 9-0 parts here, in one of the more infamous cases that they've ever decided, ruled against Carrie Buck on the grounds that since her grandmother had been crazy and her mom had been crazy, although with no support I've seen in the record, medical or legal, for either of those propositions, that the state of Virginia was justified in doing what it did. Are you ready for this? Because 3 generations of imbeciles are enough. Case was written by Oliver Wendell Holmes, one of the worst justices we ever had on the court, and this is a big reason for it. In effect, what they're saying is that we can presume you to be incompetent. Not only is that inconsistent with the original setup where we were principals and agents and we told our agents what to do, that now says, in effect, that the relationship has been transformed into guardian and ward, or maybe worse than that, master and slave. 14th Amendment, we own you. Lock, stock, and barrel, which is why they think they can do these mandatory vaccines that are upcoming in the near future. And this is how we stop them, by using this philosophical underpinning and saying, wait just a minute here, unless you can show how we went from principal and agent to master and slave, you've got a real problem here because we haven't agreed to it. And therefore, where can we find the consent of the governed anywhere to any of this bullshit? It might apply in Washington, D.C., Article 1, Section 8, Clause 17, a wholly different question with which we don't have to deal if we're domiciled in a judicial district in a state admitted into this union. Buck v. Bell, do not forget this case. Viewers out there, please subscribe, like the videos, tell your friends, get the word out. The more of us that are going to be doing this, the quicker we beat these bastards. Thank you.